Hello,
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we are going to talk about the 3 reasons why you do not have to worry about the federal estate tax exemption.
Yes.
So let's start out with giving you a little bit of a review of what the federal estate tax exemption is. And basically what it is a number that's set by Congress every single year. It goes up, it goes down, but it is the amount that you do not have to worry would be subject to any type of federal estate tax. There is also a state estate tax in some states, but not in the state of Wisconsin. So to calibrate you, this year, the federal estate tax exemption is $12.92 million, which means that if you have that and you pass away, you will not give 1 penny to the federal government. However, if you pass away and you have, say, 14 million, then the additional approximately $1 million that is over and above the exemption will be subject to the federal estate tax, which can be anywhere from 30 to 50%, just depending. So now that you've got a kind of general overview of that, let's also talk about another exception to the federal estate tax exemption.
Yeah, so there's a tale of two exceptions, okay? You have the yearly exception, and then you have the lifetime exception. Let's put this in practice. The yearly exception, a lot of people have probably heard, oh, so I'm allowed to give away $17,000 per person per year, and I'm not going to get taxed on it, right? The answer is yes. But then they ask, well, what if I give away 18? Am I going to get taxed on that? No, you're not. What if I give away 19? Am I going to get taxed on that? No, you're not. As long as you haven't given away that limit that Kirsten mentioned earlier, whatever that exemption limit is the year that you pass away, as long as you haven't given that out. The way that this works, so this year, 2023, $17,000. So let's say I give Kirsten a $17,000 check just because I like her, whatever. She paid me anyway, so just returning the favor. So I give Kirsten $17,000. Do I have to file a gift tax return?
Nope.
No, I don't have to file a gift tax return. My lifetime exemption doesn't come down. Let's say I felt really generous and I found money somewhere and I gave Kirsten $1,017,000. Do I have to file a gift tax return? Yes. So what happens is $17,000 is the exemption, so that gets wiped away. I gave $1 million. I give it to Kirsten. Kirsten doesn't have to pay tax on that this year. I don't have to pay tax on that this year. What I do is I file a gift tax return, and then my lifetime exemption as of this year comes down from that 12.92 to 11.92.
So somebody at the IRS is actually keeping track of all of this?
They certainly are.
Oh my word.
They certainly are.
Your tax dollars at work. They're keeping track of you. That's very nice to know.
And so that's why when a lot of people say, well, I gave this gift to my son, I gave this gift to my daughter this year, I helped pay for a wedding, all that, do I have to worry about paying taxes on that? For the vast majority of people, the answer is no. Unless this person had the most expensive wedding of all time and it cost $12 million, and that even if you paid for a $12 million wedding, you still got $920,000 to spend over the course of your life. And so that's something that a lot of people need to consider. There's the gift tax exemption, which is each year, and then there's the lifetime exemption.
So, okay, wait a minute. If I go and I purchase a car and I buy it, but then I let my son drive it, is that a gift?
Good question. It's not, because what this taxes it taxes the transfer of wealth. As long as you haven't transferred any wealth to your son in the form of a gift, in the form of anything else.
In the form of money only, is that right?
No, it could be money, it could be assets. As long as you haven't transferred anything to your son, you don't got to worry about it. If you let him drive it, if you let him use things, as long as you haven't sent title from yourself to your son, even if it's a $100,000 car, you got him a new Tesla or something, or you got yourself a new Tesla, let him drive it, no issue. Even if you gave him the Tesla at $100,000, great. All that means is that means your lifetime exemption, $100,000 minus 17, so $83,000 comes down by $83,000. And still, you still have $12.912 million to splurge on.
So is it safe to say that the vast majority of people are not going to need to worry about this, except if, let's say, inflation goes wild, or the value of things goes up tremendously? Like, for example, let's say the value of land goes up at an exponential rate, and now all of a sudden the acreage that you thought was worth $10 million is actually worth $15 million. Then we would have issues. Is that right?
Right. The vast majority of us, according to statistics, it's 99.7 of us 0.7% of us do not have to worry about the estate tax. We not only will we not have that amount of money, we will not give away that amount of money. So we don't have to worry about it. However, we did have a previous video of reasons to worry about it. Things change. The laws change. The thresholds change. State laws change. So some people do need to worry about it, but the vast majority of us will just not have enough money to actually worry about it.
And in all cases, it is really important to have your estate planning in place, because then you are able to actually account for this sort of thing. And one thing that we didn't discuss in the video that you were talking about is a marital property agreement. So a marital property agreement is very important as that estate tax exemption reduces, because if you are married and you have a marital property agreement in place, and it says, hey, I've got 5.5 million of exemption, you've got 5.5 million of exemption. If you pass away, your 5.5 million can port over to my side of the balance sheet. And now I've got 11 million total to be able to apply to our full estate when I pass away. And so if you do not have that magic language in your marital property agreement regarding portability, you simply won't be able to do it. The government will not allow it. However, if you do, then there is a special mechanism, and we know how to do it here, where you would be able to then effectuate that. So it's very important that you do your estate planning, and even if you think you will never hit that limit, to get that portability clause inside of your marital property agreement really helps insulate you further.
Right, and you shouldn't worry. Like I said, most people shouldn't worry about it just because the limit's pretty high. However, the limit has been really, really low in the past. The limit has been under $1 million in the past. There are certain states, as I mentioned in the previous video, where the limit is $4 million, $1 million, and so it's all something to consider of what actually, keeps you up at night, what actually is concern for you.
We have lots of clients here who have decided to just make sure that they've got their estate planning in place because they want to be sure that they have things as protected as possible, not only from this issue, but also from other much more serious issues, because the chance of having this happen is much higher. For example, my understanding of the latest statistics is there's a 50% chance that anybody who is listening to this will end up in a nursing home, and the cost of nursing home is exorbitant. And so how can we protect assets in the instance that we would have a spouse or ourselves go into that situation, and we want to make sure that we're still able to pass some of our assets on to our loved ones. So that's why it's always so important to make sure that we're looking at the full estate plan, your goals and your desires, and then putting all of that together in something that really makes sense. And so that's why we are so excited about helping you protect your today and your tomorrow. And we're grateful that you joined us. Thank you, and see you next time.